He's hoping that we're going to talk about his favorite color, maybe his favorite food.
But favorite bow tie?
Favorite bow tie. He loves bow ties. But no. We're not going to give him easy questions. Welcome back to the show, Dr. Mark Caleb Smith, Dean of the School of Arts and Humanities at Cedarville University, where he's also professor of political science and director of the Center for Political Studies there as well. Welcome back.
It is always a pleasure to be with you.
Yeah, I love to geek out with you because I was a social studies teacher, so I always feel like, we're BFFs when this is done, and it's just my favorite.
It's a blast. No kidding.
I'm so glad.
He's going to record that and play it while he's falling asleep.
Yeah. Okay, so I'm glad we're starting with lightness because it's going to stop right now. So I want to remind folks we're nonpartisan. We, as in Dr. Smith, us, we don't want to talk partisan politics. We're not gonna. Don't try to listen for it. We're not interested in it. We want to actually just have a really logical, constitutional, civics discussion about some things going on in the world. First one, today the Supreme Court will be hearing oral arguments for perhaps one of its most consequential cases in how many years would you say? Would you say in 25 years, 50 years?
Politically, probably at least since Bush v. Gore. So, yeah, since 2000.
So for those unfamiliar, what are the circumstances of the case that they're going to be hearing today at the Supreme Court?
That is such a loaded question. This is a massive case. So I'll take 30 seconds and explain everything based on your question.
Yeah. Right? Just a real overview.
No, I'm just giving you a hard time.
I know you.
All right. So the 14th Amendment, I know everyone loves to start their mornings thinking about the 14th Amendment. The 14th Amendment was written after the Civil War, and it has a Section 3 within that amendment appears to bar people from holding office if they've engaged in insurrectionary activities against the United States of America, and if they previously swore an oath to America and to the Constitution. And now we can understand the context. This is really directed at people who had fought against the Union, Confederate soldiers, Confederate politicians, perhaps, and others who rebelled actively against the country and who had previously been members of the military or politicians and chose to rebel. It was really barring them from office. And so the question the court's going to deal with today is, does this language, in their oral argument today, does this language apply to Donald Trump? And if it does, can states use the 14th Amendment in Section 3 to prevent Donald Trump from appearing on their electoral ballots?
Okay, so a lot of people's heads started to explode because you said lots of things there. But again, we're not interested in the partisan parts of this.
Right, that's right.
Now, as we go to the 14th Amendment, I got to be honest, I don't think many people spend much time there. First observation, okay, the Bill of Rights, the first 10 amendments, pretty succinct. I enjoy it, fits on a page. The 14th Amendment has 5 sections. This takes up a whole page.
It's massive. It is massive. And it's also inarguably the most important amendment to the Constitution outside of the Bill of Rights.
Why would you say that?
Because it contains language that restricts state governments in very particular ways. And the Supreme Court over time used that language to basically apply the Bill of Rights to every government in the United States of America. Because again, we don't need to get into Civics 101, but if you look at the First Amendment, it starts with this phrase, Congress shall make no law. Well, that was interpreted to mean by the court for generations that the Bill of Rights only applied to the national government and not to state and local governments. So therefore, once the 14th Amendment was passed, the court began to use that language in Section 2 to apply the Bill of Rights to state and local governments. And so now free speech rights exist from top to bottom, not just at the federal level.
And it seems to me, as I look at it, a lot of these provisions are compelling states to view African Americans as equal and Native Americans, quite frankly.
Yes, that's correct. So a lot of these things are motivated out of a desire to get rid of all the vestiges of slavery. So slavery is over because of the 13th Amendment. They've already banned slavery with the 13th Amendment. But the 14th Amendment is there, I think, to prevent states from treating people differently because of the existence of slavery at one point. So it requires states to provide people due process of the law, with the equal protection of the law and other things. And you're right. You can see a lot of this directed certainly at that issue. But the Supreme Court doesn't necessarily limit its understanding to the specific desire that was expressed when this language was written, because it's not written in a small way. It's big language. It's not written for this very particular moment. These are principles that are put in place, and the court has to decide whether or not those principles are relevant in cases we deal with today.
So no judge, or really no informed citizen, will look at the 14th Amendment and go, oh, that doesn't count anymore because they were talking about the Civil War.
That's right. No judge, and I think no informed citizen would reach that conclusion. There are an awful lot of things that we get because of the 14th Amendment, and it's not just related to the Civil War, for sure.
Yeah, it feels kind of like a catch-all amendment where they had a whole bunch of problems after the Civil War, and they're like, okay, we're going to make 5 sections and solve 5 separate problems. Is that a fair assessment?
No, that's a fair assessment, and there are people who refer to it as, in some ways, our second constitutional founding. It redefined so much of how the Constitution is understood that it really is a momentous amendment.
And now I think it's worth looking at, again, it's Section 3 with some specificity here. But before we get to that, has the Supreme Court ever made a ruling on Section 3 of the 14th Amendment?
No. They've never made a decision about its applicability in anything remotely resembling something like this.
So there's no court precedent for them to follow. They know, no matter what they do, they're setting precedent.
Because of the unique nature of the presidency and the way that presidential campaigns happen, this is a unique precedent that they're getting ready to set. And they will take that incredibly seriously because they don't have much else to rely on. And so, this is going to be it's going to be very delicate. Let's just put it like that.
And now, for those who don't follow the Supreme Court, how rare is this that the court would, for the very first time, make an official ruling on one of the amendments to the Constitution?
It's pretty unusual. Yeah, it's very unusual. Generally, I teach constitutional law, and basically I teach precedents. I teach, here's the First Amendment. Let's look at the scads of precedents that come out of litigation surrounding all these issues. And so this is highly unusual, especially as far away as we are right now from the 14th Amendment. So, this is not normal.
And as I understand it, right, when you're looking at Supreme Court precedent and their decisions, a lot of times they're defining terms. They're saying, okay, Congress wrote this law. Here's what the words they chose actually mean. Is that fair?
Yeah, no, I think we can say now that overwhelmingly all the members of the Supreme Court feel that way. That's how they go into their job. Let's look at the language of the document. Let's ascertain the precise meanings that we're working with here, and then start to think through how those meanings should be reflected given the facts that we have in front of us. So they're going to start with the text first. That's right.
And now, a lot of times what you're going to get from news media these days is commentary, where people are going to tell you what they think, right? And they're going to tell you what to think. But let's just do this. I'm going to briefly, it's not long, read Section 3, and then I want us to be able to talk about it together. And let's do it this way. I'm going to take a quick break, so we're not running too late here. We'll come back, and I'm going to take us through Section 3 of the 14th Amendment and have you help us understand what words will the Supreme Court be deciding, and do we have any idea what they're going to do, and then what the consequences will be of their possible decisions they could make. We're talking about today's oral arguments at the Supreme Court of the United States of America will, for the very first time in our history, be hearing a case and making a decision about the 14th Amendment of the Constitution, specifically Section 3. And it could influence the outcome of the election pretty dramatically. Now, we're not going to talk partisan politics here. We're just trying to understand what's happening. That's our goal. So, just for the sake of our argument here and understanding, Dr. Smith, I'm going to quickly read Section 3 for us so we can talk about terms. Because as we mentioned before the break, today the Supreme Court will decide what this means. Like when Congress wrote this in the 1860s, like what's the meaning of this for us, not just then, but today? So here we go. 14th Amendment, Section 3. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So if I'm understanding what they're writing here, they're saying anybody who holds any office, and this is what the court has to decide, right? Anyone who holds any office, state or federal, that participates in an insurrection or a rebellion, and they've held an office under oath, they can't serve again.
So
Deep breath.
the problem up front, and I understand this might sound absurd, is whether or not this language applies to the President of the United States.
Exactly.
Because it lists senator, it lists representative, it says elector of president and vice president. An elector is like the electoral college. It is not president and vice president. And then it says, or hold any office, civil or military, under the United States. So the question is going to be whether this idea of the office there, or officer, as it's listed later in Section 3, whether those two words refer to the President of the United States. And believe it or not, that is not exactly a cut and dry issue. There's this question that you have to have is why would they not list the president and vice president since they've already listed senators and representatives? Why would they ignore them? You know, it seems kind of obvious that if you're going to list these other members of the federal government, why not list the president or vice president directly? There will be arguments that the decision not to list them reflects a decision to exclude them from this.
Yeah, and I mean, it's a tough one because the first half of this section appears to be Congress at the time doing their very best to say everybody.
It appears, though. It appears that way, but it's not everybody. Now, I think you could argue the language as an officer of the United States probably does include the president or the vice president, but that's a pretty big assumption to make. Now, there's some evidence around the framing of this. We have transcripts from Congress where they're arguing about this, where one of the authors of the amendment was asked this question on the floor, whether or not the vice president and president were included.
Really?
And he basically says, duh, of course they are. But that doesn't necessarily mean that that's an authoritative response. And it also doesn't mean that everyone else who voted on the amendment would have agreed with him. And so I think it probably includes the president and the vice president, and the language is so broad that it probably should, but it is not a simple decision.
So do we know for certain whether or not the court will be deciding whether or not the president counts in this list?
Yes, I think that they're going to have to reach that conclusion if they decide that it's relevant and applicable based on other factors. I think that's one of the questions they're going to have to address, yes.
But it's not the only one because I think, and this is where lawyers drive everybody else nuts, right? But
right.
The words insurrection and rebellion,
yes,
they have to define that, right?
They do. To my knowledge, and I'm not going to claim extensive expertise in the federal code, but to my knowledge, the federal code of the United States of America does not concretely define insurrection or rebellion definitively. It doesn't give us a textbook definition of this is what we mean by this. And so generally speaking, insurrection involves a violent act against the government and against its authority. Rebellion usually refers to more of an armed, organized resistance to either overthrow that government or authority. And so insurrection tends to be a little less formal maybe and a little less organized, but it can still lead to the same kind of outcomes as a rebellion. Does that include what we saw on January 6th is really the question the court's going to get at. Does it include efforts to push back against election results surrounding January 6th, and then the calling of the rally, and then the, let's all walk down together, and then what happened on January 6th, which, again, if in a purely nonpartisan way, was a deliberate effort to short-circuit at least a constitutional proceeding that was taking place in Congress at that moment.
So they're not just deciding what insurrection and rebellion mean. They're deciding on a specific situation from January 6th, whether that counts as that, and whether or not
Correct.
former President Trump was part of it.
That's exactly right.
Now,
Yeah, that's exactly what it is.
Now, if I understand things correctly, the federal court in Colorado already made a decision. What they said was yes, yes, and yes. And now the Supreme Court's going to say if they're right or not. Is that correct?
They're going to say if they have the authority. One of the questions they have to deal with as well is whether the state has the authority to make this decision on their own, or whether there are other entities that would have to weigh in on this, like the Supreme Court or maybe even Congress. Now, I know that sounds insane, but, Brian, we were just reading the 14th Amendment. The very end of the 14th Amendment, Section 5, says Congress shall have the power to enforce by appropriate legislation the provisions of this article. There are going to be people who argue Congress has to put teeth into this and define these terms through legislation, and since Congress has chosen not to do that, or at least not recently do that, we really don't have legislation that can be enforced by a state against a president of the United States.
So does the Supreme Court act in a way sometimes where they say, this law isn't good enough, you've got to make it better?
They could say that we don't. The technical language here is whether or not Section 3 is self-executing.
Okay.
Like, does it just execute itself where you can go to a court and say, I'm challenging you based on Section 3? Or is the kind of language that requires a law to be passed in order to create a circumstance where you could have an adjudication take place? And so the court could decide that this is not self-executing, therefore it's a moot issue, Congress needs to pass legislation, and the court just punts on the whole thing. They could easily do that to say this isn't our problem anymore.
But isn't it safe to say that's unlikely because of the gravity of the situation with an election coming in less than a year?
I don't know if it's unlikely necessarily, because in doing so, they would also basically be telling Colorado and Connecticut and other states that you can't do this because Congress hasn't authorized it, and therefore your decisions aren't relevant. You can't prevent him from being on the ballot. And so this just sort of goes away at that point. And so that's one way they could kind of avoid settling a lot of issues and let the election kind of unfold as they see fit. Now, I think that'd be a little bit of a punt, a little bit of just an avoidance mechanism. But the court routinely tries to avoid difficult situations because they just don't want to insert themselves politically.
Because that's not their job.
Can you imagine? We can talk about this, but can you imagine what the outcome will be if the court says, oh, yeah, you can go ahead and do this, and President Trump or some future president gets struck from 25 state ballots? I mean, imagine the outcome of that. I mean, so the court doesn't want to jump into this without being very, very sure of what it's doing.
So what are the other possible outcomes that could come out of this?
They could say that there's basically one big standard at work here, and President Trump just simply doesn't qualify to be on any ballots because we've decided the language applies to him, the circumstances apply to him, and therefore he's barred from holding office. The court decides it, and it's over at that point. Now, it does tell you in Section 3 that Congress can override this with a two-thirds vote potentially. And so Congress could circumvent it if they choose to, but good luck with that, right?
Yeah.
So they could do that. They could also say we're going to let states work this out. Let states make the decisions that they want to make based on their own circumstances. We're not going to settle it. The Constitution's there. It allows states to have the flexibility they wish. But again, I think if they do that, you'll see a lot of states step forward and try to limit President Trump's access to the ballot. Or they could decide the language just doesn't apply to him. He wasn't engaged in insurrection. Maybe they would even say the people who went into the Capitol were engaged in insurrection, but he was not. And therefore, they're not willing to say that the language applies to him and the election sort of moves forward as we might expect. So lots of options are on the table for the court, and I'm sure other ones that I haven't thought of.
And since we don't have any court precedent on Section 3 of the 14th Amendment, we really, I mean, pundits can say what they want, but does anyone really have any idea what they're going to do?
No, not really. And even when we have oral arguments today, people will speculate that they now know what the court's going to do, and they don't either. And so the oral arguments will be interesting. It'll be revealing to some extent, but reading too much into oral arguments is a pretty consistent mistake. So, we'll see what they do. And they can hand down a decision relatively quickly, or they could also take their time on this, and this might not be handed down for a few months.
And now perhaps most importantly, and this is what we can offer that other media sources can't, we're followers of Jesus. You are a follower of Jesus. It's one of the things I admire most about you is your deep faith in Jesus that supersedes even your passion for politics. Because you're a pretty passionate guy about politics. You have all the degrees in it, and you teach it.
Yep.
So How are you approaching this in terms of how you're going to think and feel about the case itself and whatever the outcome is in light of your faith?
Yeah, I mean, I think that at the end of the day, it doesn't matter. And let me be very careful how I say that. It doesn't matter because it's all part of God's unfolding plan. And in the end, his glory will be revealed one way or the other. And so even if it goes the direction I would prefer, or if it doesn't go in the direction that I would prefer, I really try hard to not let these kinds of issues get into the center of my life and become idolatrous, or become so wrapped up in them and absorbed in them that I lose perspective and lose priorities. And so this would be momentous, but it doesn't define the future. It doesn't remove God from his throne. And in the end, honestly, doesn't define the United States of America. Every time we're going to hear this is the most important election. Yeah, well, every election they say is the most important one. The country moves forward and God's still on his throne.
And how do you maintain that? Because, so many Americans that without the credentials are passionate about politics. It's like they care, Christians in particular, care about the direction of the country. So how do you temper your emotions?
It's good to care. But I think, I always think of Augustine. Augustine wrote this majestic work, The City of God, and he tells us that we as Christians have basically one eye on the earthly kingdom and one eye on the heavenly kingdom. And if we misthink, if we put both eyes in one or the other, we're losing our responsibilities and our obligations. So if we're focused completely on the heavenly kingdom, that we forget to pursue justice here on earth, we've failed to some extent. If we focus completely on the earthly kingdom and forget what God's doing overall, then certainly we're too wrapped up in the here and now. And so there's this constant balance that you have to strive for. And so I'm not saying it's easy. But I think that's our goal, and I think Augustine was a good model of it, and I think that should be one of our virtues that we try to pursue as believers.
So then, I guess at the very ground level, let's just say the Supreme Court decides this soon. They'll eventually decide it, regardless.
Yep.
Talk to the person who's really happy or really mad about their decision. Now, they're a follower of Jesus.
Yeah.
What's your advice to both?
Yeah. If you're really happy, I'm sorry, but in the future, this is going to be used against you. So whatever happens, the other side is going to use it against you at some point. And so I appreciate that you're happy, but this is a temporary victory, most likely, no matter what the outcome is. If you're sad about it, there's a path forward no matter what. There really is. And our politics will recover no matter what. Whether you think he should be banned or not banned, our politics will recover regardless. And so I tend to still have some faith and hope in the American people, believe it or not. And sometimes it's hard to do that, but I think we're going to be good politically.
And God's sovereignty, correct me if I'm wrong, extends to the outcome.
Absolutely.
So whatever the outcome is, God ordained it.
Absolutely. And I can take some comfort and some hope in that as well.
There you go. All right. Well, we did it. Look at us.
Everybody's an expert now. That's great.
Yeah. And we're both still here, and the world didn't end. So we made it. Okay. So, again, Dr. Mark Caleb Smith is Dean of the School of Arts and Humanities and Professor of Political Science and Director of the Center for Political Studies at Cedarville University. For more information, I highly encourage you to go to cedarville.edu. Again, cedarville.edu. As always, I'm grateful you're willing to let me ask you some of the hardest questions.
It really
Anyone
is,
can
it is
grapple
a good
with.
time. It's a lot of fun, so it's always a pleasure.